what if analysis. If I go with an extension of the bid for the next 1 month, what would be my chances? And if I step out and go away, what will be my kind of a face? That's the time the GC plays a very important role. He had to map every situation. He need to really show like a picture. The picture is something which should be self-descriptory, and that gave a wonderful thought. And at the end of it, it is said, please don't go ahead with the bid. That's a kind of an advisory I have given, which the company has taken. Finally, we withdrew from the bid. Story could be simple, but the point I'm trying to make is that a managing director of a major company, in terms of going ahead with a $1 billion job, taking the absolute consent and the consultation from a general counsel shows in absolute good light the kind of a beacon we are talking about it. As to why we are withdrawing, there is a showcasing, we need to do it. So I think this is very important. Now there is a lot of regulatory environment where we are playing in India. For the sake of my foreign guests, I would like to say that there is a lot of regulatory environment. To handle the regulatory environment, it is only the GC and the GC who can really see the dimensions of what is likely to come through, because they have got enough exposure, and that's where GC would add value to every organization. This is how I would sum up.
Thank you, panel, for at least initiating this talk. And what I can see is within our audience, we have a lot of lawyers, law firms, and specialists, especially cyber and all. So I'd like to possibly invite some questions from the audience, especially on the topic that, as you recognize, that a GC is a bridge between the management and the outside world. So from the perspective of the outside lawyers, how do they perceive the GC's function? And what is it that they look forward when they interact with the company? Maybe James, because of your experience, in case you could start.
Well, I can offer some reaction to what I've heard. I think in the U.S. the view of the GC is very similar, but not exactly the same. I'm not sure the GCs in the U.S. get involved in business decisions if they're purely a GC. But if they're a GC and a general counsel, or rather a GC and a vice president, then they do have additional responsibilities. But, you know, when you start to blur the lines between business advice and legal advice, you start getting into a number of different problems, including whether or not there's an attorney-client privilege and things like that. But there's another issue that I think a lot of people worry about, is that when you're at the center of things, if you just visualize for the moment you're standing in the center of a circle, at best you can see only half the circle at any given time. You can turn around and see the other half of the circle. But if you can move yourself a little bit off the center, you can see more and more of the circle. And if you take yourself completely outside the circle, you can see the whole circle. And that's the conflict sometimes that one has when you're rendering legal advice and you're in the center of the circle. And in those circumstances, you probably would welcome the independent view of outside counsel. And in terms of adding value, every employee is supposed to add value. So it's not just a role that's unique to the GC. And in part, knowing when it's a function that you can perform as a GC, and knowing when it's something that should involve outside counsel, it becomes really important. I don't know if that's what you had in mind, but those were some of my reactions to what I heard.
In fact, James, it's a very valid point what you have raised, and I'm sure that this panel out here already has seriously introspected on that. The fundamental point that you have raised here is that the GC in the West, even though he may be with the company, but he still holds an independent view. And I think that's a fundamental difference between the West and our out here in India at least. A GC is still not being perceived as an independent decision or possibly opinion maker. My thought with my colleagues out here.
Yeah, thanks, Ram. James, you did mention about client attorney privilege in the US. Vis-a-vis India, the position is that the General Counsel in India will still be seen as non-practicing legal professionals and not treated at par with an attorney under the Advocates Act 1961 here. And it's on my own personal view is that it should not be the case, and the most recent of the Bar Council of India rules, which do talk about recognition being made periodically relevant and license being renewed, being just made applicable to only attorneys who practice in the courts. And that's a big and fundamental difference in this jurisdiction. So the point that we have some privilege is not there here. As a general counsel in India, I would still be seen as somebody who is sticking as an employee, who is advising the business as an in-house counsel. So it's a misnomer to some extent that the term general counsel is applicable in India in a manner as equatable to what is done in the US. That's the major difference according to us. And I have been a general counsel or an in-house counsel for the last 2.5 years, and prior to that an in-house counsel for about 23 years. And I have seen that time and again when we go to the management and advise them, we advise them in the spirit of actually upholding law, regulation, even an executive action which is proper in perspective vis-a-vis the business. But still it's considered a view of an employee who is trying to lobby around with the management of the company. That's the status that we have today. So to cut it short, yes, we are responsible legal professionals in the company who will look at all the dimensions of affecting the business with vis-a-vis the law and regulation. And if we have to superimpose a particular position for the company beyond our own advice, we do go to external counsel, get their opinions. And that is a practice which continues to be followed. You would like to add?
Well, I would just like to add that as a GC, yes, you rightly said, we are in a circle, and when we look at an issue, we also try to walk a little out of the circle and see how much of the bandwidth we get. But we don't work in isolation. We do take the support of external counsel where there is a need for us to do so. Because all of us, we appreciate and we recognize the fact as a general counsel, as an in-house general counsel, our bandwidth may be just this much. But when we go to the senior counsels outside, their exposure with number of other industries, we could get another angle. There are times when we as such as general counsel are broadly in the know as what we need to do and what should we do and how should we proceed. Nonetheless, we do go outside to outside counsel to get a reinforcement and to make sure that whatever we do as a general counsel is in sync with the business interest and in sync with the law of the land. So we both of us work together in harmony and collaboratively.
I think just to add, I have nothing really much to add, but I think there isn't that kind of an independence that we talked about. You are part of the organization. You are an employee. The opinion that you bring to the table, it's in the best. It has the best of the professional and the legal piece, and the all the research and all of that is brought to the table, I think. But at the end of the day, it's an employee. You bring forth the problem. You come forward with a solution, and I think then you top it up with the external advice and put it forth to the management as to the best possible solution in the given circumstances. But yes, there isn't that kind of an independence that James, you pointed out.
Badri, anything you need to add? Gagan, I would like to ask you, what's your take from a UK perspective on this? On the GC's role, say, especially from the Europe part and UK in particular?
I think it depends. In my experience, I've come across different kinds of GCs at different organizations. Some are a lot more, shall we say, hands-on than others. Some are more interested in the academic side of law than others. Some see themselves almost as external lawyers to an internal business client. And I think some rely on external counsel to differing extents. So it's, I wouldn't say there's a uniform UK perspective. But we, I think, as external lawyers, have to work with in-house counsel regularly and need to understand their needs, the challenges that they face, and trying to give them whatever support we can from the other side.
Thank you. One question which I'd like to ask the panel is, in India, there is multiple roles being performed by the GC. For example, a GC is also a general counsel, come company secretary, come risk officer, and keep on adding the titles. My personal view is that a GC should remain a GC. That is a fundamental core area of niche. And in case he wants to assume the other roles, possibly he could have dotted line relationship or maybe people under him to oversee the entire function, rather than taking up both the role of a company secretary and a GC. Any thoughts that the panel would have on this? Because this is quite unique only to India. I don't think so it works anywhere else.
I think this is a very perennial question ever since we came into the profession, whether we should handhold for the secretarial responsibility, or whether as GCs we should only stick to the kind of legal advisory kind of a role which we have been performing. I think there is a conflict of interest. There is a clear conflict between a compliance officer, between a company secretary, and that of the GC. It's in my opinion, and as per the established conventions and principles, they are mutually parallel activities, and they cannot be. There can be kind of a reporting relationship, but there can never be the same person who would be responsible for it. For two reasons. One is that what's the role of the GC? GC's role is predominantly to advise the company to facilitate how best to do a particular thing. Some of the secretarial compliances and the kind of a compliance related issues, they would probably inhibit this kind of a perspective in the GC. I think to that extent the role of the GC could be diluted if the other functions are taken over. So it's my personal opinion is to completely de-link the secretarial function from that of the GC role.
I mean, I'm going to support Badri. I think there is a conflict of interest. There is a position that gets diluted. As the risk and the compliance officer, there is a specific role that the person needs to discharge. And as a GC, there is a specific role in terms of, troubleshooting, in terms of, closing contracts, in terms of adding contracts, and there's so many other things that a GC would do. So in a conflict situation, I think the best approach would be to de-link and keep it separate. That's my personal view.
You go ahead. Well, I don't agree with both my other two panelists. While I'm waiting to shed my company secretary designation, we're grooming someone to take over. Having said that, I don't think there's any conflict of it. Because we do not compromise the compliance or the legal thing just because we hold two portfolio as a GC and a company secretary. It just definitely means that you must have the bandwidth to make sure that you do not compromise either of the two roles. As a company secretary, you know what the requirements are. As a GC, you know what your role in the organization is. So both can go together. So though of course, personally asked me, I would like to, I've done enough of company secretary role. I want somebody to take it from me and take it. But that's a different thing. But they can both work together.
I have a view which is actually a mix and match. The reason why I am saying that is just like a differentiation has been applied in the previous panel discussion on banking system, and within the banking system NBFCs being separate vis-a-vis the RBI regulation. I would like to say there are organizations or companies which impact the economic system irrespective of their status. So in a country where you see systemically important organizations or groups functioning at a major level of impacting the industry, whichever industry they are in, then the role of the General Counsel is at a very high elevated position in terms of authority that needs to come with it. And that role should not be compromised with that of giving it an additional capability being given. This I am telling out of my own experience of having seen how Godrej Group itself has looked at company secretary compliance, governance issues of independent corporate bodies that the group has promoted. While there are independent company secretaries, the General Counsel position for the corporate legal as a Godrej Management Committee would expect is now surviving on the basis that yes, you are empowered to give an opinion of a particular scenario having been looked at by the Management Committee. Because the Management Committee cuts across all the business entities, because entities are only vehicles for the business. And therefore, while corporate governance, compliance, secretarial compliance are left over to the individual businesses, issues that I talked about, would be it anti-bribery, FCPA, issues connected to governance, reputational risk, these become more paramount and much more beyond the corporate entity's existence, and including the latest law with reference to prevention of sexual harassment against the women. So when these kinds of issues crop up, it's the General Counsel who will set the ball rolling, saying what is the standard that needs to be set by the organization. And that's where I think the dichotomy has to happen, and that needs to happen in organizations which will have a bigger impact for the economy. If they lose face, if they lose reputation, what will happen to the entire sector or industry? Because these are the people who lead the particular sector or the industry. That's where I would like to say I have a mix and match view. So systemically important corporate organizations of an economy need to elevate a General Counsel role, and they do not need to mix and match the positions of governance, positions of secretarial compliance. Thank you.
Shifting focus from the role of the GC, I come to another very important problem which the GC has to face, which is rising legal cost. Given the multiplicity of the cases, given the multiplicity of the jurisdictions,